The era of emancipation and expansion in the U.S. demanded a direct political attack on the power of the Supreme Court. And now Associate Professor of History at Princeton, Matt Karp, he's calling on the left to take note of Abraham Lincoln, who challenged the power of the judiciary system during the Civil War era.
So once in power, Lincoln and congressional Republicans reorganized the federal judiciary, and they passed legislation banning slavery in federal territories that was in direct violation of the Supreme Court ruling in Dred Scott. Jacobin contributor Matt Karp joins us to explain how Democrats might need to take note of some of this history with impending battles over the courts. Great to see you, Matt.
Good to see you, Matt.
Could you just lay out the history for us? What happened and how did Abraham Lincoln approach the Supreme Court?
Yeah. So in the 1850s, the Supreme Court was dominated by Southerners, by Democrats, even which was effectively the pro-slavery party in this period. And even the Northerners on the court largely sided with Roger Taney and the sort of pro-slavery majority, and that came to a real fruition. Of course, listeners may know about the Dred Scott verdict in 1857, which ruled that even as the country's entangled in this feverish debate about the future of slavery, the Supreme Court rules that, in effect, this entire debate is unconstitutional. Black Americans have no rights. A white man is bound to respect. And slavery cannot be prohibited in the territories. There's a constitutional right to property and slaves. And in effect, rules out the entire platform of the Republican Party, the anti-slavery party. So what do Republicans do about it? Do they say, oh, well, we need to somehow win an election and then replace the justices and figure out how to abide by this ruling and yet somehow maintain our politics? They directly put the court under political fire. This is maybe the most important lesson, I think, is not so much the procedures, but the effort to politicize the court and to sort of reject what they call the superstitious worship of the Supreme Court. This court is the citadel of slavery, as one Republican argued, and we intend to storm it. These judges were political appointees, and they should be regarded as such. So, in effect, there is a three-part political war on the court. First, this rhetorical attack on the court as somehow above politics, pushing back against that idea. Second, questioning this idea of judicial supremacy, that the court always gets to decide political questions. Lincoln rejected that. His vice president, Hannibal Hamlin, rejected that, said they do not have the right to decide a political question for us. The people, as Lincoln said, will then have ceased to become our own rulers. And then finally, the third thing is procedural. Then when Republicans took power, they made significant efforts to reorganize the circuit court system based on population to make it more democratic. And they added a justice, and effectively, when necessary, they ignored Supreme Court precedent with, for instance, the ruling to abolish slavery in the territories, or Emancipation Proclamation itself, of course, was flagrantly unconstitutional according to Dred Scott, but the Supreme Court by that point had been so thoroughly muzzled, had been so thoroughly politically defeated and recognized it that it did not object.
So this was the success. Yeah, I'm really fascinated by number two in that point about judicial supremacy. What is the actual way in which you can challenge judicial supremacy in the way that we are right now? Because I think you're right, which is that one of the main issues I see is that people have been trying to kick all this stuff to the courts so they don't have to answer for it themselves in the legislature. But how would you actually force legislators to actually legislate and not kick things to the court? You're kind of in a catch-22 situation.
It's complicated, and this is in some ways above my pay grade. I'm not a legal scholar, but I would say in the historical example, I mean the essence of what Republicans were most concerned with was this idea that an unelected judiciary could decide a political question that should be decided by the people, and the appropriate outlet to decide political questions are the representatives of the people. That, namely, especially in Congress. I think there are a lot of parallels in some ways between the 1850s and today, in the sense that the anti-slavery forces in that moment felt they had a very clear popular majority that they had awakened in opposition to slavery, that the overall majority of the country, stood against the rule of the slave power, the extension of slavery into the West, and the domination of the federal government by slaveholders and their allies. And yet they had so little, and the only branch they controlled at different points in the 1850s was the House of Representatives, as as the kind of, the branch closest to the people.
Wait, one sec, Matt. What are you pointing to on that issue? I don't see anything even close to the same level of popular support which exists, which isn't represented in government.
I mean, I guess the argument from the left is that the right increasingly is reliant on counter-majoritarian institutions like the Senate and the Supreme Court and the Electoral College, and that the broad coalition, left of center coalition, increasingly has popular support that exceeds its kind of institutional support through those counter-majoritarian channels. That's the parallel I'm talking about.
Sure.
Yeah.
I just don't see what policy, like, there's nothing even comparable, really, to what we're talking about here, which is not like getting passed or something with regards to slavery.
Well, I mean,
right?
Look, really speaking really narrowly here,
Yeah.
I mean, you could say the Democrats' number one priority, and I've been on the show half a dozen times. I'm not a fan of the Democratic leadership in any respect. I don't think they have an agenda that's commensurate to our country's problems in any shape or form. But if you look at H.R. 1, this is the bill that the House is behind that is just basically a voting rights bill that would significantly, I think, strengthen democracy, make American democracy closer to the people, allow the people to rule, which is supposedly what this country's about. And the forces that are blocking that are primarily counter-majoritarian right-wing forces, i.e. the Senate, then ultimately the president, and then the Supreme Court would probably try to jump in on that and overrule it somehow. And I don't think that we can, even at that, and that's not even a radical policy. I mean, this is a voting expansion bill, and yet it's far less radical than some of the alternatives that are being mooted. And yet we kind of implicitly understand that these counter-majoritarian forces on the right are eager to block it in any way possible, even if they don't have a popular majority. And I don't think that we should sort of meekly accept that.
And so, Matt, what is your practical expectation for what your much beloved Democratic leadership that you've just come out as a total shill for? Just kidding there, that's sarcasm. What do you think that they're actually going to do? Because the truth is they get something out of this arrangement, which is it's one more, brick in their impenetrable wall of excuses of why they can't do more. I floated my radar today. You can just see Joe Biden being like, I wanted to do the FDR thing, guys, but the darn courts, we just can't do it. They're going to reject whatever we send up. So sorry, we're going to have to go for, something much smaller and much less consequential. So they don't really have any interest ultimately here in challenging the Supreme Court because they like to be impotent.
Yeah, I mean, I think there's a good case for that. It's hard to know what happens when, what constellation of forces are in power. I do think there is a heightened partisanship that expresses itself in a certain kind of procedural radicalism coming from unlikely quarters, that will still end up, I think, at this moment is still, totally inadequate to the task. But, you even have Pete Buttigieg talking about 15 Supreme Court justices. Granted, it's a sort of idiotic idea where you're going to have 5 nonpartisan judges, and it's wrong-headed. But I think there are things that are sort of spilling through the cracks procedurally. Now, for me, I wouldn't be surprised to see a more tenacious procedural resistance in a number of ways within the Democratic Party, win or lose in this election. What I think the problem is, for me, ultimately, yes, when it comes to a really big bill, when it comes to something that actually might be on the scale of the problems this country faces, like the fact that tens of millions of people don't have health care and are going bankrupt because of it, at that point, I think the current Democratic leadership lacks the boldness and, in fact, the conviction to challenge these counter-majoritarian institutions, and would probably be happy to sort of mediate and temporize between them and then use that as an excuse in the same way that, how are we going to get Joe Manchin to vote for it? How are we going to get, John Roberts to get on board with this? And it becomes an excuse for sort of, insufficient incrementalism. So that's totally possible. I do think, though, jumping ahead of ourselves to sort of say, well, this will never happen is not where the left should be right now. I think we need to know who our enemies are, absolutely, or what our opposition is. But I also think we need to say, look, if there's a moment where people are frustrated with, these unrepresentative elites at all sorts of state levels of the government that are blocking popular will, we need to resist that. And whoever's on board with that, even if they are establishment Democrats, then I'm with them on that particular front.
Yeah.
It just seems to me that you're crafting a popular will argument that always conveniently aligns with the left, and that if you had those elements of power, that you wouldn't be making that argument. And I don't know, like, let's say there were 5-4 majority of liberals on the Supreme Court that struck down something on U.S. immigration law, which is counter-majoritarian force. I don't think you'd be on the show arguing against it. I just don't.
Well, I mean,
Yeah.
you might have another person on the show, but
Yeah.
I think we have to. I mean, look, I'm committed to taking this plunge. I think the people have to rule. So I think we have to have that debate, including about immigration, in public. And I know that, look, I think it's complicated. I'm not saying that the courts have no role to play in adjudicating the law. But I think that the part that Republicans were most focused on in the 1850s, and the part that I'm most focused on, is when a legislative majority which is the people's representatives at the most base level, passes legislation, it should not be taken for granted that the court has the supreme power to overturn it. And now and I think Democrats and the left has to start to think that the appropriate field to argue these questions is the political democratic one, not the jurisdicratical one.
Sure.
And
I think
that
that's
includes the ones that we're on defense rather than on offense, according to the polls. But I think that's the ground to fight that fight. I mean, do you agree with that, Sagar?
Yeah, no, I think you're absolutely right, which is we should move it much more towards popular democracy within the legislative branch. Totally agree. Thank you for joining us, Matt. Really interesting.
Thank you,
Great.
Matt.
All right, good.
Great piece.
Good talk.
Next on Rising, the Trump campaign talks about the ground game and fundraising. That's when Rising continues.